Hello viewers, in this lesson we will learn about the features and administration of Securities Contracts Regulation Act 1956. Viewers, now we will learn about the basic structure of the Securities Contracts Regulation Act 1956 and some important definitions under the Act. Objectives and application of the Act. With the background of the earlier lessons, the students now should realize that the stock markets in India play a very pivotal role in the development of the Indian economy, as the stock markets facilitate mobilization of funds from small investors and channelize these resources into various development needs of various segments of the economy. To prevent undesirable transactions in securities and to provide a foolproof mechanism in this regard, the Parliament had enacted the Securities Contracts Regulation Act 1956. This legislation contains the provisions relating to the powers of stock exchanges and the Securities and Exchange Board of India. Under the Act, the rights of investors, the penal provisions, procedures, offences, appeal to the Securities Appellate Tribunal, the rules and regulations thereon. The preamble of this Act states that this Act is enacted with an objective to prevent undesirable transactions in securities by regulating the business of dealing therein by providing for certain other matters connected therewith. This Act extends to the whole of India, including the state of Jammu and Kashmir. This Act came into force on 20th February 1957. Under Section 28 of this Act, the provisions of this Act shall not apply to the government, the Reserve Bank of India, any local authority, or any corporation set up by a special law, or any person who has effected any transaction with or through the agency of any such authority as referred to afore. Further, the provisions of this Act do not apply to any convertible bond or share warrant or any option or right in relation thereto, insofar as it entitles the person in whose favor any of the foregoing has been issued to obtain at his option from the company or other body corporate, issuing the same or from any of its shareholders or duly appointed agents, share of the company or other body corporate, whether by conversion of the bond or warrant or otherwise, on the basis of the price agreed upon when the same was issued. The central government has the power to exempt any contracts from the purview and application of the provisions of this Act. Basic structure of the Act. This enactment contains 31 sections. Sections 1 to 2A contain the preliminary provisions. Sections 3 to 12 deal with stock exchanges, their recognition procedure, powers and functions of the stock exchanges, and the related provisions. Sections 13 to 19 contain the provisions on contracts and options in securities. Sections 21 to 22F contain the provisions on listing of securities and the appeal to the Securities Appellate Tribunal and the further appeal thereon to the Supreme Court. Sections 23 to 26 relate to the penalties and the procedure thereof. Sections 27 to 31 contain the provisions on miscellaneous issues like the rule making power, savings, and such provisions. Students are advised to thoroughly study the Securities Contracts Regulation Rules 1957, the Securities Contracts Regulation manner of increasing and maintaining public shareholding in recognized stock exchanges, Regulations 2006, the Securities Contracts Regulation, Stock Exchanges and cleaning corporations, regulations 2012, and conditions of listing agreement with stock exchanges, and all other revised rules, regulations, circulars, notifications issued from time to time by the central government and the Securities and Exchange Board of India. Students also must study the Securities Laws Amendment Act 1995, 1999, 2004, the Securities Laws Second Amendment Act 1999, and other related amendment acts which can be referred to from the bare acts. Important definitions. 1. Contract. This term is very significant as the Act relates to the securities contracts. Under Clause 8, Section 2 of the Act, contract means a contract for or relating to the purchase or sale of securities. 2. Demutualization. According to Clause AB to Section 2 of the Act, demutualization means the segregation of ownership and management from the trading rights of the members of a recognized stock exchange in accordance with a scheme approved by the Securities and Exchange Board of India. This provision must be read with the provisions under Sections 4A, 4B, and 5 of the Act, which contain a detailed procedure for corporatization and demutualization of stock exchanges. 3. Securities. This term has been very elaborately described in Lesson 1. Clause H to Section 2 of the Act defines this term. However, this definition is inclusive and not descriptive. 4. Stock exchange. Clause J to Section 2 of the Act defines stock exchange as any body of individuals, whether incorporated or not, constituted before corporatization and demutualization under Sections 4A and 4B, or a body corporate incorporated under the Companies Act 1956, whether under a scheme of corporatization or otherwise, for the purpose of assisting, regulating, or controlling the business of buying, selling, or dealing in securities. With effect from 12/10/2004, corporatization of all stock exchanges is compulsory as provided under Sections 4A and 4B of the Act. 5. Recognized stock exchange. As per Clause F2, Section 2 of the Act, a recognized stock exchange is one which is for the time being recognized by the central government under Section 4 of the Act. 6. Derivative. Under subsection 33 to Section 2 of the Companies Act 2013, a derivative is one as defined in Clause AC of Section 2 of the Securities Contracts Regulation Act 1956. The said clause AC is not descriptive but inclusive and states that a derivative includes a security derived from a debt instrument, shares, loan, whether secured or unsecured, risk instrument or contract for differences, or any other form of security, and a contract which derives its value from the prices or index of prices of underlying securities. This term is well explained further in Lesson 2. There are other terms which are discussed elsewhere in this lesson. Further, under Section 2A of the Act, words and expressions used in this Act but not defined in this Act but defined in the Companies Act 1956 or the SEBI Act 1992 or the Depositories Act 1996 shall have the same meaning respectively assigned to them in those acts. Viewers, now we will learn about the law on the stock exchanges. Stock exchanges and their recognition. Sections 3 to 12A of the Act contain the main provisions on recognized stock exchanges. Securities can be listed only in recognized stock exchanges. The power of granting recognition to a stock exchange is vested with the central government under Section 4 of the Act. Under Section 3 of the Act, any stock exchange seeking recognition must make an application in the prescribed manner to the central government. It should furnish the bylaws and rules of the stock exchange, which should contain the necessary details, like the details of the governing body of the stock exchange, its constitution and powers of management, the manner in which the business is transacted, the powers and duties of the office bearers of the stock exchange, the rules of admission, details of membership, the procedure for registration of the partnerships as members of the stock exchange, and such other related matters as stipulated under Section 3 of the Act. The central government may grant recognition to the stock exchange as provided under Section 4 of the Act if it is satisfied that the requisite formalities are complied with after making such inquiry as may be necessary and after obtaining any such further information, if any, as it may require. The central government may impose such conditions as it may feel necessary for granting the recognition. The central government must ensure that fair dealing and investors' protection are carried by stock exchanges before granting recognition. The central government may impose such conditions, including the conditions relating to the qualification for membership of stock exchange, the manner of entering into contracts, representation of central government on the board, and the maintenance of auditing of accounts. Corporatization and demutualization of stock exchanges. Corporatization and demutualization are explained afore. With effect from 12/10/2004, all recognized stock exchanges must be corporatized and demutualized before the appointed date under Section 4A of the Act. Appointed date means, as per the explanation given to this section, the date which the SEBI may, by notification in the official gazette, appoint, and different appointed dates may be appointed for different recognized stock exchanges. Sections 4A, 4B and 5 of the Act deal with this subject. If there is any delay in corporatization and demutualization of a recognized stock exchange, the SEBI is empowered to condone the delay on sufficient cause shown. Under Section 4B of the Act, the procedure for corporatization and demutualization is stipulated. Students are requested to thoroughly study these provisions. The stock exchanges must submit a scheme for corporatization and demutualization to the SEBI. The SEBI may make necessary modifications, and further it may also restrict the rights of shareholders or stockbrokers, and also the maximum number of representatives of the stockbrokers, which shall not exceed 1/4 of the total strength of the governing board while approving the scheme. Once the scheme is approved, every recognized stock exchange must, either by fresh issue of equity shares to the public or any other manner as may be specified by the regulations made by the SEBI, ensure that at least 51% of its equity share capital is held within 12 months from the date of publication of the order by the public other than the shareholders having trading rights. The SEBI, on sufficient cause being shown to it and in the public interest, may extend the said period by another 12 months. Withdrawal of recognition. Under Section 5 of the Act, the central government is empowered to withdraw the recognition granted to a stock exchange in the interest of trade or in the public interest. The central government must issue a notice and give an opportunity of being heard to the stock exchange before passing any order of withdrawal. Non-compliance with the provisions under Section 4A and 4B of the Act also will result in withdrawal of the recognition. However, the validity of any contract is not affected until the derecognition is notified. Other important issues relating to the recognized stock exchanges. Section 6 of the Act empowers the central government to call for periodical returns or direct inquiries to be made. Under Section 7, every recognized stock exchange must furnish to the central government its annual reports. Section 7A empowers the recognized stock exchanges to make rules restricting voting rights subject to the approval given by the central government. Section 8 of the Act empowers the central government to direct the recognized stock exchanges to make any rules or to amend any rules. Section 9 empowers the stock exchanges to make bylaws. Section 10 empowers the SEBI to make or amend bylaws of a recognized stock exchange. The central government is empowered to supersede the governing body of a recognized stock exchange. Under Section 12, the central government is empowered to suspend the business of a recognized stock exchange. Under Section 12A, the SEBI may issue such directions to any stock exchange or clearing corporation or agency or person or class of persons associated with the securities market or any company whose securities are listed or proposed to be listed in a recognized stock exchange as may be appropriate in the interest of investors in securities and the securities market. Sections 13 to 19 deal with the contracts and options in securities. The conditions for listing securities are narrated under Sections 21 to 21A. A clearing corporation is one which is a company incorporated under the Companies Act 1956 and carries the duties and functions of a clearing house with the approval of SEBI. Section 8A of the Act contains the necessary provisions. A recognized stock exchange may, with the prior approval of the SEBI, transfer the duties and functions of a clearing house to a clearing corporation for the purpose of the periodical settlement of contracts and differences thereunder, the delivery of and payment for securities, and any other matter incidental to or connected with such transfer. The clearing corporation must make bylaws and submit the same to SEBI for approval. The provisions of sections 4 to 12 shall apply to a clearing corporation as they apply in relation to a recognized stock exchange. Viewers, now we will learn about the penalties, the Securities Appellate Tribunal and other related matters under the Act. Penalties. Sections 23 to 23K contain the provisions on the penalties. The penalties are very severe as they are imposed against economic offences. Under Section 23, if any person violates the provisions of Section 6, that is to file periodical returns and furnish such information as required by central government, or enters into any contract in contravention of the provisions contained under section 13, which relates to the declaration of the government that contracts in certain notified areas are illegal, or section 16, which relates to the power of central government to prohibit contracts in certain areas, or contravenes the provisions contained in section 17 relating to licensing of dealers in securities in certain areas, or section 17A relating to public issue and listing of securities pertaining to any certificate or instrument as stated under subclause IE of clause H of section 2 of the Act, or section 19 relating to the prohibition of working of stock exchanges other than recognized stock exchanges, or enters into any contracts in derivative in contravention of section 18A, or the rules made under section 30 of the Act, or comes under violations specified under clauses E to I of subsection 1 to section 23, is liable for punishment with imprisonment for a term which may extend to 10 years, or with fine which may extend to 25 crore rupees, or with both. For contravention of the provisions contained in sections 15, 21, 21A or section 22, the punishment is similar as stated afore. For failure to furnish information, returns under section 23A, or failure to enter into an agreement with clients under section 23B, or for failure to redress investors' grievances under section 23C, the penalty is 1 lakh rupees for each day during which such failure continues, or 1 crore rupees, whichever is less for such failure. For failure to segregate securities or monies of clients under section 23D, the penalty is not exceeding 1 crore rupees. For failure to comply with listing conditions or delisting conditions under section 23E, or for an act of excess dematerialization or delivery of unlisted securities under section 25F, or failure to furnish periodical returns under section 23G, the penalty may be extended up to 25 crore rupees. Where no separate penalty is provided for any such violation, under section 23H, the penalty is up to 1 crore rupees. Section 23I empowers the SEBI to appoint any officer not below the rank of a division chief of the SEBI to be an adjudicating officer for holding an inquiry in the prescribed manner after giving any person concerned a reasonable opportunity of being heard for the purpose of imposing any penalty in respect of the aforementioned penal provisions. The adjudicating officers must take into account the factors enumerated under section 23J. Under section 23K, all the penalties realized shall be credited to the Consolidated Fund of India. Under section 23M, if no punishment is provided for any violation under the Act, the punishment could be with imprisonment for a term which may extend to 10 years, or with fine which may extend to 25 crore rupees, or with both. If the penalty imposed is not paid, or the directions or orders of the adjudicating officer are not complied with, the punishment is with imprisonment for a term which shall not be less than 1 month, but which may extend to 10 years, or with fine which may extend to 25 crore rupees, or with both. Under section 23M, the tribunal or court can compound the punishment. Securities Appellate Tribunal. Under clause GB of section 2 of the Act, Securities Appellate Tribunal means a Securities Appellate Tribunal established under subsection 1 of section 15K of the SEBI Act 1992. Students are advised to refer to these provisions. Under section 23L of the Act, any person aggrieved by the order or decision of recognized stock exchange or the adjudicating officer or any order made by the SEBI under section 4B may prefer an appeal before the Securities Appellate Tribunal, and the provisions of sections 22B, 22C, 22D and 22E of the Act relating to the procedure and powers of the tribunal shall apply to such appeals. Where a recognized stock exchange refuses to list the securities of public companies or collective investment scheme, the aggrieved company may file an appeal under section 22 to the central government. However, this right is not available after the commencement of the Securities Laws Second Amendment Act 1999, as under section 22A, the right of appeal is provided to the Securities Appellate Tribunal. Sections 22A to 22F also contain the provisions on the powers and functioning of the tribunal. The students are also advised to refer to the provisions under sections 23O to 31 on power to grant immunity, offences by companies, the power to make rules and regulations by the central government and SEBI. Viewers, I hope you have enjoyed this session. We will meet again. Thank you.